हाय गाइस, आई एम आयुषी, योर मेंटर फॉर लॉ एंट्रेंस एग्जाम्स एंड वेलकम टू लॉ डाइजेस्ट। ये जो हमारी लीगल करंट अफेयर्स की सीरीज होती है, हम यहाँ पर सारे इंपॉर्टेंट जजमेंट्स जो हैं हर मंथ के वो कवर करते हैं। सो इन टुडेज वीडियो वी आर गोइंग टू कवर नवंबर मंथ ऑल द इम्पॉर्टेंट जजमेंट्स एंड ऑल्सो प्लीज नोट कि ये जो वीडियोज हैं इसमें मैं सबसे इंपॉर्टेंट केसेस डिस्कस करती हूँ। अपार्ट फ्रॉम दैट देर आर मोर, आई होप यू स्टडी देम at your own end. Either you use Google, or you can also check our website www.lawdigest.in, जहाँ पर we provide you with the module wherein we cover all the cases. Now, starting with the first case, State of Jharkhand versus शैलेंद्र कुमार राय. This case basically pertains to the two finger test. इसके बारे में मैंने अपने Instagram post में भी काफ़ी डिटेल में डिस्कस किया था that what is two finger test and क्या उसके ऊपर लीगल प्रोविजंस रहे हैं एंड कोर्ट का क्या कहना रहा है. नाउ इन दिस पर्टिकुलर केस जब हम बात कर रहे हैं टू फिंगर टेस्ट की, सुप्रीम कोर्ट ने ये बोला है, सुप्रीम कोर्ट हैज सेड that persons who are conducting these tests, they will be held guilty of misconduct, because Supreme Court said that we have been discouraging this practice for a long time, and this test does not have any scientific basis. ऐसा नहीं बोला जा सकता. It cannot be said that if a woman is going through that two finger test and she's passing it, that does not mean that if she's sexually active that she cannot be raped. ऐसा कहना बहुत गलत होगा, and it actually it's re-victimizing the person. एंड इसके अलावा कोर्ट ने काफ़ी डायरेक्शंस इशू करी. द कोर्ट डायरेक्टेड द यूनियन हेल्थ मिनिस्ट्री टू इंश्योर दैट जो सेक्शुअल असॉल्ट एंड रेप सर्वाइवर्स हैं, दे आर नॉट सब्जेक्टेड टू दिस टेस्ट. यूनियन गवर्नमेंट, स्टेट गवर्नमेंट्स को डायरेक्ट किया गया टू इंश्योर दैट द प्रॉपर गाइडलाइंस आर फॉर्मुलेटेड बाय द डिपार्टमेंट ऑफ हेल्थ, जो और हॉस्पिटल्स वगैरह में भी सर्कुलेट करी जाए. एंड इट ऑल्सो डायरेक्टेड कि आप वर्कशॉप्स कंडक्ट कराइए फॉर हेल्थ प्रोवाइडर्स टू कम्युनिकेट द अप्रोप्रिएट प्रोसीजर, कि आपको किस तरह से एक सेक्सुअल असॉल्ट के विक्टिम को कैसे एग्जामिन करना है. उसके लिए देयर शुड बी अ प्रॉपर प्रोसीजर एंड देयर शुड बी प्रॉपर वर्कशॉप्स फॉर इट, सो दैट पीपल आर मोर सेंसिटिव. And also to review the curriculums in the medical schools, so that two finger test is not prescribed for examining rape or sexual assault survivors. Then moving forward, Gujarat State Civil Supplies Corporation versus Mahakali Foods. इस केस में basically the thing was that when there is an arbitration agreement, it is understood that in case there is a dispute, the dispute will go to an arbitrator. So here the Supreme Court said that if a reference is made to a facilitation council, it applies to all the MSMEs, micro, small, and medium enterprises. So, under this act, if there is any reference between the parties that is being made to the facilitation council, despite the fact that there is an arbitration agreement between the parties, then this reference is maintainable, and the facilitation council can decide on the dispute, despite the fact कि arbitration act बोलता है कि अगर आर्बिट्रेशन एग्रीमेंट है तो आप डिस्प्यूट को आर्बिट्रेशन से ही सॉल्व करोगे. मूविंग फॉरवर्ड, डायरेक्टोरेट ऑफ इन्फोर्समेंट वर्सेस पद्मनाभन किशोर. This case pertains to the issue of bribes. Now, basically, in this case, there was a Madras High Court judgment which said that, which actually quashed the PMLA proceedings against a bribe giver. So, a person who's giving a bribe, he was under question for PMLA Act, that is Prevention of Money Laundering Act, and he was being questioned. And so, High Court, Madras High Court, had quashed that judgment against him. But the Supreme Court said that the person who is giving that bribe, he's giving it with the intent. So by handing over the money, he's showing his intent of giving bribe, and such person will be assisting and will be a party to the activity of the crime. So it cannot be said that there is no active participation on his part. And also, without his participation of giving that money does not assume the character of being a proceed of a crime. The moment he gives it with the intent to give a bribe, then that is wide enough to cover such person under the PMLA Act. Then Ashwani Kumar Upadhyay versus Union of India. Here the Supreme Court directed the central and state governments ताकि जो भी legislations हैं All the legislation should be published in regional languages so that better access can be ensured uh, for people whose day-to-day lives are being governed by those legislations. And it is logical enough that these legislation should be published in regional languages as well, because language is a barrier for many people. हाउएवर कोर्ट रिफ्यूज टू एंटरटेन अ प्रेयर जहां पर ये रिक्वेस्ट भी करी गई थी दैट पब्लिकेशन ऑफ ड्राफ्ट लेजिस्लेशंस बिफोर देयर इंट्रोडक्शन should also be published in the regional languages, but the court said no to it, and only after the legislation has been passed it should be uh, published in regional languages as well. That is what the court said. Janhit Abhiyan versus Union of India. This is the major case pertaining to the EWS reservation, also covered on Instagram post. So please make sure that you're following us on Instagram so that as and when we come out with these updates, you get them instantly rather than in the monthly compilations. Now, in this case, this is a 3 is to 2. A constitutional bench sat for this case, and this case was judged by a 5-judge bench, wherein 3 is to 2 majority upheld the 103rd Amendment, which introduced the EWS criteria that provides 10% reservation for people who belong to the EWS classes. There's a criteria, full criteria as to who are the people who are belonging to EWS. We're not getting into the details here. Now here, Justice Dinesh Maheshwari, Justice Bela Trivedi, JB Pardiwala Justice, all of them, they concluded, they gave their majority opinion. And on the other end, Justice Ravindra Bhatt, he was there for the minority opinion, and uh, the ex Chief Justice of India, Justice UU Lalit, had concurred his view. So these judges, this can be important for people who are preparing for CLAT PG, because such kinds of questions are asked. Now, what was held? Uh, Although I've covered it in detail earlier, here I just like to tell you that in brief, it was held that ye jo 50%, there's a criteria. As per the Indrasani judgment, you cannot exceed 50% reservation. And it was being, said that you are exceeding that 50% limit. But here, the court said that that 50% limit that was set, it is not inflexible. If there are exceptional circumstances that justify, then it can be breached. This breaching of this limit cannot be said to be a violation of the basic structure of the constitution. Also, it was said that time and again it needs to be revisited. The percentages, all these things need to be revisited, because the systems change, the society change, the economic standing of people might change, so it is very important to keep revisiting. So time was a factor that the judges stressed upon. And they said that reservation is an exception to the general rule of equality. So there's a general rule of equality that all people are equal, but then reservation is an exception to this, and it cannot be said that it is a basic feature of the constitution and cannot be changed. Equality is the basic feature, reservation is the exception. And even recently, there was an LLM student who challenged the concept of reservation, and he said that reservations should not be there, and Supreme Court came down heavily upon him, imposing costs that this is just a publicity stunt. With this, we're done with the cases for this particular month. आपको, or if you want to have a look at more cases, there are more cases. Look them up online, check websites, check Google, and also you can check our website for the module. And just in case you're looking for more such videos, you want to stay legally updated, and you want careers relating to your legal career, your profession, current affairs, everything we provide on our channel. Keep following us here, subscribe to our channel, also follow us on Instagram for instant legal updates.